Welcome to SR&ED Newsletter 2013-1, where we discuss the definition of the SR&ED project. The Canada Revenue Agency, or CRA, recently consolidated its SR&ED rules and procedures into a single document. This includes comparison of the CRA's 3 eligibility criteria to the Tax Court of Canada's 5 eligibility questions, and its recommendations on the steps required in the process of recording projects. We will examine these directives in the form of a project documentation template, and then examine specific pronouncements by the tax court as to relevant documentation for each of these steps. On December 19, 2012, the CRA consolidated its SR&ED directives into a single document. Though the CRA claims it does not represent any new policies, it does remove ambiguities and provide additional clarification in certain areas. One of the notable clarifications is the comparison of the CRA's 3-step eligibility criteria to the 5 steps used by the Tax Court of Canada. The Canada Revenue Agency describes an eligible SR&ED project as, quote, a set of interrelated activities that collectively, 1. attempt technological advancement, 2. to overcome technological uncertainty, and 3. are pursued systematically by qualified individuals. It can be noted that the terms technological advancement and systematic investigation are the only of these terms used in the Income Tax Act. The Income Tax Act definition defines SR&ED as, quote, a systematic investigation or search that's carried out in a field of science or technology by means of experiment or analysis. It can be basic research without a specific practical application in view, applied research with a practical application in view, or experimental development, which encompasses the above two. That's namely, quote, any work undertaken for the purpose of achieving technological advancement, for the purpose of creating new or improving existing materials, devices, products, or processes, including incremental improvements thereto. This statement leads claimants to the obvious question, what is a technological advancement? The Tax Court of Canada's SR&ED requirements are represented by a 5-step process. This 5-step process has been outlined by the courts in various cases, including the landmark case of Northwest Hydraulics. In that, the judge asked the following questions. 1. Was there risk and uncertainty? 2. Definition of a hypothesis. 3. Use of the scientific method. 4. Resulting technological advances. And 5. Did the client retain adequate records of the work? It should be noted that question 2 also includes its own 5-step process to evidence the testing of a hypothesis. Before we look at the specific components of an SR&ED project, let's examine the role of the Tax Court of Canada in determining SR&ED eligibility. In the case of RIS Christie, the judge stated, quote, what constitutes scientific research for the purposes of the Act is a question of law to be determined by the Tax Court of Canada, not expert witnesses. The expert's role is limited to providing the court with a set of prescription glasses through which technical information can be viewed before being analyzed and weighed by the trial judge. In the author's view, this 5-step process is a great guideline on how the claimant should document an SR&ED project. The judge clarified that the steps required to illustrate a scientific hypothesis include A. Observation of the subject matter, or perhaps defining the field of science. B. Formulation of a clear objective. C. Identification of technological uncertainty. D. Formulation of hypothesis to remove the uncertainty. And E. Systematic testing of the hypothesis. These steps outline the scientific method as addressed in the judge's question number 3. Based on the pronouncements of the Tax Court of Canada and the Canada Revenue Agency, we propose the required steps for documenting an SR&ED project would be Step 1A. Define standard practice for the field of science in question. Step 1B, define objectives that go beyond standard practice. Step 2, correlate experiments to uncertainties. We propose this requires identifying the key variables for experimentation. Step 3A, ensure the work was done systematically by documenting experiments and comparing the results to objectives. And Step 3B, clarifying the technological conclusions, which involves explaining results by a deeper understanding of the interactions of the stated variables. If we compare the scientific method as defined in the Oxford Dictionary, we can see that it parallels the recommended process outlined by the Tax Court of Canada. The second column illustrates how we recommend this information be captured in a project reporting template. Finally, we'll evaluate a detailed comparison of the Tax Court of Canada's 5 main questions to the CRA's 3 eligibility criteria. Ideally, we're going to illustrate how the requirements are addressed and documented in our proposed project template. Some of the major additions we feel could be relevant include a further focus on defining A, the state of standard practice at the outset of the work, B, the specific variables of experimentation, and C, reinforcing use of the scientific method. We will illustrate that the tax courts have addressed each of these issues within their pronouncements, but on many of these issues, the CRA is still silent. We will now examine specific pronouncements by the tax court judges with respect to each of the 5 steps. In the case of Northwest Hydraulics, the CRA argued the work was routine engineering since the claimant had used all of the devices before. The judge disagreed with the CRA position since the claimant proved that the innovative combination and alignment of these devices carried elements of technological uncertainty which went beyond the standard practice usage. This case outlines the importance of benchmarking the steps taken to review the existing or standard practice methods, which would be typical for such a project, and clarify why they are not applicable to the current environment. Once this step is performed, identifying the variables of uncertainty would then provide evidence that the hypothesis goes beyond standard practice models. Notably, in the U.S. SR&ED tax credit system, IRS auditors are required to provide evidence of such methods if they intend to deny claims on the basis of standard practice. In the author's opinion, this level of accountability would be an excellent measure for the CRA to adopt as well. Step 1B, quantification of objectives beyond standard practice. The case of SAS Manufacturing and Northwest Hydraulics both stress the importance of, quote, extremely accurate measurements and the expectation of infinitesimally gradual results. As such, the quantification of objectives becomes a starting point for such work. Step 2, correlating experiments to technological uncertainties or hypotheses. In the author's view, the pivotal point of project eligibility concerns the existence of technological uncertainties and the related hypothesis to resolve them. The tax courts define hypothesis in several tax cases, including CW agencies and Maritime Ontario Freight Lines. Amongst other things, these definitions clarify that hypotheses are 1. Tentative assumptions, 2. Based on existing facts, and 3. Are a basis for further investigation. In the case of Northwest Hydraulics, the judge claimed that they would ultimately examine whether the variables under experimentation could have been resolved using standard practice methodologies. Again, highlighting the variables seems to be the determining factor on whether the investigation was systematic with controlled experiments or random and trial and error investigation, which would be ineligible. Since the tax courts generally look to the generally accepted definitions of words to interpret their meaning, we believe the following definitions are relevant to the definition of a scientific hypothesis. A, that a scientific hypothesis requires that one can test them. B, they are based on observations which cannot be explained with existing theories or models. C, they normally follow mathematical models. And D, they represent a proposed basis for further testing. One of the earliest publications on the science of design was Design of Experiments, first published by Sir R.A. Fisher in 1935. This book provides guidance on the use of matrices to test the variables within the theories in what is today referred to as the DOE, or Design of Experiment model. We have found that strong SR&ED projects are those that can identify and rank the variables of uncertainty. Conversely, where the research team is unable to identify the variables of experimentation, it becomes more difficult to prove A, that the work was done systematically via controlled experiments, and B, that it went beyond existing standard practice models. Step 3A, ensuring work was done systematically. To ensure the work was done systematically, the judge in SAS Manufacturing indicated that the claimant needs to both A, correlate the research steps to stated hypothesis, and B, keep adequate records of this work. In the case of Rainbow Pipeline, the judge also clarified that being methodical or systematic was a requirement, but not in itself proof of SR&ED. To be systematic investigation as contemplated under the Income Tax Act, the judge noted that it must also follow the entire scientific method, including formulation and testing of untested hypotheses. The judge in Rainbow Pipeline also commented on evidence of technological advancement as required by the Income Tax Act, that the rejection after testing of a hypothesis nevertheless can represent a technological advance, and that it proves or eliminates an untested hypothesis. Challenging the science officer's opinion. The tax court rules permit the taxpayer to challenge the knowledge or credentials of a CRA expert witness. Sadly, at the review stage, the CRA does not allow similar such challenges, so taxpayers may find themselves in court in situations where they believe a CRA reviewer has an appropriate background in their field of science. Rules, there are general and informal procedures. The general procedure is not only costly and time-consuming, but the CRA will also hold assessments on all future claims until an issue is resolved. As a result, it may be in a claimant's interest to agree to limit the amount in dispute to $12,000 per taxation year in order to get swift resolution to an issue. Once resolved, they can then apply the tax court ruling to this issue in future periods. Various dispute options are outlined in the following table. The first three involve negotiating directly with the CRA personnel, who typically use only their own directives and documents. The fourth step involves the use of judges and lawyers, who only consider the Income Tax Act legislation. If the courts determine inconsistencies between the Canada Revenue Agency documents and the tax legislation, the Canada Revenue Agency is required to correct these deficiencies. Whether you're an SR&ED claimant or you assist companies in filing claims, we welcome you to test our R&D-based software to A, compile SR&ED projects online, B, upload all data to your income tax software, and C, then leverage this information to claim patents and implement intellectual property strategies.